There's no seeming end of quotes regarding people's views towards laws, and more specifically, lawyers. Some views are positive, some are funny, some are positively scathing. But it got us to thinking about legal systems and how we relate to them, which naturally got us to thinking about how the Soviet legal system was constructed. And what we found was that the Soviet legal system was multi-layered and complex in its formulation and evolution over the life of the USSR. This, of course, meant we needed to explore it further. I'm your host, David, and today we are going to start looking at the Soviet legal system. This is the Cold War.
You know what should be illegal? Not knowing about Boxu. So, let me tell you. Boxu is a monthly snack box subscription service that delivers original assortments of premium Japanese snacks and tea pairings right to your door. Every month, you'll receive a box with a different theme. The snacks will always be different, so it becomes a new gourmet journey through Japan every month. This month, Boxu has a specialty Kiribako box in store, and this limited edition holiday box is a must-have for any fan of Japanese history. Boxu makes such a perfect and memorable gift for anyone in your life who appreciates Japanese snacks and culture, especially during a time when people aren't able to travel as easily as they would like. Actually, not only would you be gifting them Boxu, which is already awesome, but you would also be giving them the chance to win free tickets to Japan, because Boxu is having a giveaway. They will be picking one lucky winner to win a free set of tickets, and anyone who's subscribed before December 31st is automatically entered. The link is in the description. Check out the terms and conditions and other methods of entry. Don't forget to use our code COLDWAR10 and the link in the description to get 10% off and save up to $47 on your own authentic Japanese subscription box from Boxu.
The relationship between the Soviet state and the law is a peculiar subject. It was highly driven by ideology, especially in the early days of the Soviet Union. At that time, the state was being constructed largely from scratch, with most of the Tsarist-era institutions and structures being deemed either obsolete, a leftover of the authoritarian imperial past, or too heavily laced with bourgeois influences. The replacement legal system was to be driven by Marxist-Leninist theory, instead of a system whose core purpose had been to defend the ruling class and their wealth and property. A new system was being introduced whose sole purpose was to protect and defend the worker. In the words of Justice Nikolai Krylenko, a Stalin-era commissar, quote, "For us, for the workers and peasants state, no form of court is acceptable except one which always and under all conditions will guarantee the defense of the interests of the workers. All state authority is nothing but a weapon of social force and constraint, with the aid of which a given governing class in a given society realizes its political sovereignty and guards its economic sovereignty." End quote. This was a concept called proletarian law, which stipulated that no legal, procedural, or moral considerations should prevent the carrying out of revolutionary justice. The best example of this is that the death penalty was abolished in 1917, but this didn't stop the execution of political rivals, deserters, or of White Guard supporters, all in the name of revolutionary justice. So we can see there's already a deviation between ideals and practice. The role of analogy in Soviet law is also telling. For those of you not familiar, in law terms, reasoning by analogy involves referring to a case that concerns unrelated subject matter but is governed by the same general principles, and then applying those principles to the case at hand. Meaning that if a person was being tried for something where there was no specific provision for the crime, the case wouldn't be dropped, but an analogous provision would be used to met out punishment. The logic driving this was that the specificities of the law or procedural barriers shouldn't act as an impediment to the carrying out of revolutionary justice. This does highlight, however, that the Soviet legal system shouldn't be seen as an autonomous institution of the state, but rather as a tool to further state policies. The use of analogous reasoning in Soviet law lasted until the early 1950s, at which time Stalin began a process of legal codification. He sought to make the system more formalistic, building on the 1936 constitution, which he had implemented. The Soviet legal system was proclaimed a just system, which would ensure an orderly transition to communism. Along with this, for the first time, the constitutional principles of organization of the work of the courts was also being established. Article 112 of the Constitution stated that judges were independent and accountable only to the law. But were they really independent? Well, as Justice Krylenko is alleged to have said, quote, "The independence of judges is not their independence from state policy. We do not need independence, which would envisage not taking anyone else's consideration into account." End quote. So, judges were independent, provided they judged the way the state needed them to. Now, how did laws get created in the Soviet Union? Well, to start with, it needs to be acknowledged that the separation of power between the legislative and executive bodies of the Soviet Union wasn't really a thing. The Communist Party was recognized as the dominant and driving force in the USSR. So, on paper, the Supreme Soviet of the USSR, the state parliament, was the highest lawmaking body in the country, but in practice, most lawmaking decisions were made by the executive branch. The Supreme Soviet would only convene twice per year for about a week each time, and they would elect the members of the Presidium, a committee whose job was to carry out the duties of the Supreme Soviet in between those sessions. This included adopting the laws and decrees issued by the Communist Party. These adoptions would be rubber-stamped with little to no discussion at the next session of the Supreme Soviet. Oftentimes, these laws wouldn't even be passed individually, but instead as packaged blocks, done this way in order to save time. We also need to consider, however, that in the absence of the Supreme Soviet passing laws, ministries and industries would simply pass their own laws, which, although they could conflict with broader Soviet laws, would be the ones that ended up being enforced. So the 1936 Constitution also paved the way for a greater degree of division between different types of laws, as well as creating more structure and order in the Soviet legal system. During the new economic policy period in the 1920s, there were 7 legal codes: criminal, labor, land, civil, criminal procedure, civil procedure, and forest. These only became more codified in the post-Stalin era, including new legal codes for the Union republics. Between 1958 and 1977, the number of legal codes for the USSR was expanded to 15 different codes, creating more structure to the system. Now, like pretty much everything else, Stalin's death in 1953 sparked a series of changes in the Soviet legal system. It began to liberalize, even if only moderately. The first to go in 1953 was the Military Tribunal and Prosecutor's Office inside the military branch of the Ministry of Internal Affairs. Along with that, the streamlined procedures when trying state crimes was also eliminated. In 1955, a prosecutorial review process was established for the Soviet Union, which granted a certain degree of supervision over the preliminary investigation of a case, even by those brought by the state security bodies. This helped to at least reduce the level of arbitrary sentences that had been rampant under Comrade Stalin. Well, somewhat anyway. In 1956, as Khrushchev really kicked off the de-Stalinization process, the legal system began to be decentralized, with the Ministry of Justice of the Soviet Union being abolished and its functions delegated to the Supreme Courts of the Union republics, as well as the Legal Commission, which was overseen by the Soviet ministers of the Soviet Union. This put the Supreme Court of the Soviet Union as the highest judicial authority in the country, even after a 1957 decision to delegate some of its authorities to the Supreme Courts of the Union republics as well. One of the devolved powers was that the Supreme Court of the Soviet Union lost the ability to demand to try any court case in the country that it wanted. The Supreme Courts of the republics gained this ability, while the Supreme Court of the USSR could only change decisions of the Union Republic courts if the decision was in contravention of Soviet laws or it was deemed a decision that ran counter to the interests of the other Union republics. Okay, so that's a general overview of the judiciary and its relationship to the government. But what about the courts themselves? How did they work? Well, they looked pretty different from many court structures in the West. So let's start by looking at the lowest level courts, the district or city people's courts. They would try the majority of criminal and civil cases and operated below the provincial courts, who acted as the court of appeal. Above the provincial courts were the Supreme Courts of the Union republics, whose primary role was to supervise the work of the lower courts. They conducted judicial reviews in the event of complaints against the Procuratura, the public prosecution offices. They would also deal with challenges from the Supreme Court of the USSR, as well as state their opinions on any legal disputes between the autonomous republics within their region. Now, the Supreme Court of the Soviet Union was at the top of the judicial pyramid, but performed a similar function as the Supreme Court of the Union Republics, dealing with inter-republic conflicts, as well as performing constitutional interpretation for the Soviet state. The Supreme Court of the Soviet Union also oversaw several specialized court branches, including military tribunals and the transportation courts, themselves split between water transport courts and railway courts. This was a split that was created by Khrushchev, by the way. Now, both civil and criminal cases that came before the court were tried in a different fashion than certainly the system I'm used to seeing here in Canada. Cases would be tried by one people's judge and two layperson judges, which, on paper at least, had equal authority. Any individual over the age of 25 who qualified to vote was allowed to stand for election to be a people's judge. The election would then happen by means of a direct and secret ballot, with ballots being cast by the citizens who were registered in the city or district for which the election was taking place. A people's judge would be elected for a 5-year term. The layperson judges were chosen by workers' collectives for a period of 2 years for a district, city, and military court, or for a 5-year term for all other courts, including the Supreme Court of the Soviet Union. The layperson judge, once selected, would serve for 2 weeks per year, but longer if it was necessary for a long trial. And some of you may be asking why include laypersons who may not have been familiar with the finer nuances of jurisprudence. Well, it was to ensure that there was a popular and democratic participation in the judicial system of the Soviet Union, or at least present that image. Court decisions would be made by a majority vote of the judges, although we really do need to point out that in practice, the lay judges would often just vote the same way as the people's judge. And what about the jury, you may ask? Well, no need to worry about a jury, since the Soviet Union just didn't use a jury system. So anybody can become a judge and exercise judicial independence then, right? Well, no. As you can probably imagine, the political reliability of both people's judges and layperson judges was extremely important for the Soviet system. As a result, the vast majority of judges, both kinds, were members of the Communist Party. But not only were judges expected to be ideologically pure before starting the position, there was additional coercion to ensure that they remained loyal to the system and didn't go rogue, so to speak. The courts and judges were highly dependent on the executive committees of the local Soviets for their material provision. Any judge who went against the grain could be punished by the committees through such things as longer wait times for housing, or by denying access to choice educational institutions for the judge's children. But it didn't have to be even that big. It could be as simple as denying proper heating to the judge's courtrooms. There's a story told by the Soviet legal professor Ioffe, who alleged the chief of the administrative department of the Leningrad Committee of the Communist Party said in a closed meeting, quote, "Yes, you judges are independent and only subordinate to law, but you are dependent on me, are you not?" By the way, like all Soviet citizens, judges were supposed to have some experience working in factories or working in the social services. They were also expected to have taken some courses regarding the study of Soviet law. Now, let's talk about court proceedings. They were public, with the exception of cases related to state security, which could be but weren't automatically closed. Proceedings were conducted in the language of the Union Republic in which they were being held, and translators would be provided for those who either didn't speak the language or did not understand the content of any judicial documents. The most common cases tried in courts were related to things like theft, assault, homicide, housing disputes, and public drunkenness. Judges were not bound by precedent, which meant that each case could be tried on its own without regard to how other judges had tried similar cases. Soviet courts also tended to be quite informal. The judges would sit at a table at the head of the courtroom, while a court clerk would sit at the side of the table. The defendant and their lawyer would stand in front of the table. Proceedings lacked the specificities and technicalities found in most Western courts and largely consisted of the judges interrogating the defendant, calling witnesses who would then be interrogated by the judge, and the lawyers for both the defendant and the prosecution. And what about Soviet lawyers? Well, they were nothing like the modern stereotypical Western lawyer, wheeling and dealing their way through cases. No Saul Goodman, even if you did need a criminal lawyer. Instead, lawyers in the Soviet Union received modest wages and were more like clerks than effective defense counsels. Prosecutors and investigators were in charge of preliminary investigations and had the right to hold an individual in custody for up to 60 days without official charges. The accused did not have the right to legal counsel during the preliminary investigation, allowing the prosecutor to often obtain testimonies favorable to the prosecution and not to the defense. So, criminal prosecution in the Soviet Union was often highly dependent on and influenced by campaigns organized by the Communist Party against specific crimes. For example, if there was a campaign against theft of socialist property or public drunkenness, the number of arrests being made for these would immediately go up. Minor crimes or infractions that might have been otherwise overlooked or ignored were specifically targeted for a period of time until a new focus was decided on, and then the arrests would focus on that. This does mean that for anybody researching crime stats in the Soviet Union, a sudden spike in the number of arrests for a certain thing didn't necessarily mean that more of that crime was happening, just that it was being focused on. Another unique element in the Soviet legal system was the Comrade courts. These had existed prior to the Great Patriotic War, but they were boosted by the adoption of a draft model statute on Comrade courts in October of 1959, creating common and uniform regulations for these courts. As a result, the number of these courts in use rose from a few hundred to 197,000 by 1964. So, what were the Comrade courts? Well, they were courts that would deal with minor offenses, like hooliganism, minor thefts, home brewing, and the like. The Comrade courts lacked the penal and custodial authority of other legal structures and instead, as their only sanction, could force offenders to publicly apologize and repent, while also issuing public warnings and reprimands. There were no people's judges in the Comrade courts, only layperson judges elected from the housing and working collectives. So instead of relying on the threat of penal authority, the Comrade courts relied on public embarrassment to punish minor legal transgressions. People's personal lives, their actions, their family relations, and bad habits, all of this was discussed publicly during these trials. One defendant is quoted as saying, quote, "I am ashamed to appear before the comrades with whom I work. Really, it is easier to endure a stricter punishment than the stern court of the collective." End quote. The Comrade courts became an effective way of dealing with minor offenses and also substantially decreased the workload of the People's Courts, who, before the introduction of the Comrade courts, were dealing with all of those minor offenses. The Soviet legal system was substantially different from that employed in the West. Both the legislative and judicial branches were completely dependent on the executive branch, which was the Communist Party. There could often be conflicting laws, depending which jurisdiction a person found themselves in, if a ministry had just passed a law that they felt necessary for conducting their mission. Legal professionals didn't hold the same level of prestige that they do in the West, although, to be fair, most people I know aren't generally really crazy about lawyers. Leave your best lawyer jokes in the comments. Ultimately, the legal system in the Soviet Union was less about truth and justice for the working man and more about maintaining and even extending the power and control of the Communist Party. We hope you've enjoyed today's episode, and to make sure you don't miss all of our future episodes, please make sure you subscribe to our channel and have laid charges of public drunkenness against the bell button, who really is a good person, but just had a bad day and drank too much samogan on the tram ride home and decided that their walk to the Khrushchevka would be better without pants or a shirt. Press the bell button and be kind. I'd like to take this opportunity to thank all of our patrons, since without your help, none of this would be possible week after week. If you aren't a patron, please consider supporting us at patreon.com/thecoldwar or through YouTube membership. We can be reached via email at thecoldwarchannel@gmail.com, and we're active on Facebook and Instagram at The Cold War TV. This is The Cold War Channel, And as we think about the Cold War, I will leave you with the words of JFK. In the final analysis, our most basic common link is that we all inhabit this small planet. We all breathe the same air, we all cherish our children's future, and we are all mortal.